Excellencies, dear participants, I would like at first to thank you warmly, the organizers of this meeting. And I am very proud to participate with you in this meeting that is dedicated to celebrate 25 years of HCCH Child Protection Convention. This convention, which means a lot to me as a Moroccan, because my country was contributed to its drafting and is considered the first country to sign it. Regarding the topic of my intervention, that I was assigned by the HCCH as Kafala in the context of the HCCH 1996 Child Protection Convention. In fact, a topic like this needs some time to discuss its various aspects, but I will try to focus on some of the problems raised by the Kafala at the international level. But before that, let me remind you of the relevant requirements writing the Kafala under the HCCH 1996 Convention. As it is known, this convention treated the following. Firstly, referring to Kafala as one of measures intended to protect the child's person or money. Ensure recognition and implementation of safeguards related to Kafala, establishing cooperation between the authorities of the state's parties in order to ensure better protection for children, completing social reports regarding children placed under Kafala, the obligation of states to take protective measures for the benefits of children under Kafala, adoption of the principle of tribal consultation for the receiving states of the Kafala before making a decision to assign it. Article 33. After this reminder, I will briefly review some of the problems posed by Kafala at the international level as follows. Firstly, Kafala and the right to family reunion. By observing the practices of the administrations of many states party to this convention, it can be noted that they refuse to grant the right of family reunion to children under Kafala. This position constitutes discrimination between children under Kafala and child compared to other situations, such as adoption, especially since the term Kafala has become known in international conventions like HCCH, Child Protection Convention, and New York Convention on the Rights of Child. Second point is the converting Kafala to adoption. Some families who take children under Kafala, once the child has traveled to the country of residence or after a period of time has passed, resort to applying before the courts of those countries in order to convert the Kafala into adoption. This situation is inconsistent with the Hague Convention of 1996, considering that the status of the child as a guarantor is recognized on the territory of the states parties in accordance with the provisions of the Convention in this regard. And any change from kafala to adoption in the status of a child constitutes a violation of the Convention. It is opposed also to the Convention on the Rights of the Child of 1989, in particular Article 20, which states that consideration of the ethnic, religious, linguistic, and cultural origin of children deprived of family care must be given consideration. It is in conflict with the Hague Convention of 29 May 1993 on child protection and cooperation in international adoption. Article 4, especially Article 4, required that adoption be approved by the child's states. Number 3, we can find another discrimination regarding the child's rights under kafala to family benefits. In this context, the child under kafala doesn't benefit from the financial allocations provided by the states of residence compared to the adoption child. Finally, I would like to note the position of the European Court of Human Rights in its decision used in 2012, which stated that it is not possible to adopt a child who has been received in the framework of kafala, and that the French law prohibiting the authorization of adoption if the national child law prohibits adoption doesn't conflict with the rights to respect for private and family life. I think this is a good decision because it took into account the specificity of the kafala system and preserved the cultural privacy of the child. Thank you very much for your attention.